welcome to the College of Complexes. This is our 302nd meeting since we started in February of 2009. We put a different speaker on every week, a different subject. We require our speaker to take a position on an issue or express a point of view. They had to be for or against something. We don't care what it is. We give them an hour to make a presentation. If they go over an hour, we cut them off. If anybody interrupts the speaker, remind the interrupter. We only listen to one fool at a time. Then we have questions and answers, questions from the audience, not speeches. The speaker gets to stay here and answer the questions. Then we have remarks, rebuttals. Everybody in the audience that wants to gets 5 minutes at this podium to respond to the speaker said for or against. The speaker gets a comment and close the meeting. That's how it works. We don't pay our speakers to give them a free dinner or our compliments, them and our guests, and we charge everybody else $3, so we pay for the speakers there in the advertising. We don't make anything a lot of fun. Anyway, before we put on our speaker, and now is the time for announcements. Does anybody have any announcements they want to make? Now is the time to make them. Any announcements? Come on up here. I knew you had an announcement. I'm just waiting for you.
At one of our local public libraries that I hang out at, I found an announcement about a man named Dr. Michael Weisberg, who wrote a book called The Hospitalist. And this book is how medicine is transformed from being a healing art to just being a business. And I think what he talks about in this book is how you can protect yourself if you have to go in the hospital, or better yet, how you want to stay out of the hospital. Now, unfortunately, I was going to attend his, but I thought it was tomorrow afternoon, and it was this afternoon, so I missed it. But there's going to be an encore presentation a week from tomorrow, February the 7th, at the Half Price main bookstore on Northwest Highway. So if any of y'all want to go, I recommend it. I brought a few little folders here that he's got a website, so you can check it out further to make sure I didn't misunderstand anything. But also, I took the liberty of putting Tom's email address on their on his list there, and they'll send out a notice when he's going to talk in Dallas, and maybe Tom can send it around to the rest of us, y'all, so in case you're interested. But you know, I thought, you know, maybe in this crowd there might be people trying to learn how to avoid going into the hospital, but maybe not. I'll leave these right here.
Good evening. Since we're making announcements about presentations outside of this venue, I thought I would mention that this Thursday, February 4th, at 7 p.m. at the Bachman Recreation Center in Dallas, David Silverman, the president of American Atheists, will be speaking and signing copies of his new book. And apparently, public's welcome, to the best of my knowledge, so you might want to come out and hear Mr. Silverman speak. He's been on several TV shows. He's debated lots of religious leaders. He's been on the Bill O'Reilly show, inspired with him, and lots of other people on the Fox network. So should be an interesting evening. Thank you.
Hi, I'm Marvin McDowell. A week from tomorrow, Sunday the 14th, Valentine's Day, I'll be giving a presentation on Las Vegas at 5-star residence near here. It's on La Sierra, near Walnut Hill and Central. The program will not just be a travelogue, but have some humorous anecdotes. There will be wine, snacks, and it's totally free. If you'd like to come, it's going to be from 5 to 6 p.m.
Any other announcements? What's the address?
Oh,
Can you read my writing?
I think
La Sierra.
La Sierra.
La Sierra?
It's off Central Expressway,
All right.
north of Walnut Hill.
North of Walnut Hill.
You can't miss it. It
All
used
right.
to be a Hyatt residence for seniors.
Okay. Any other announcements? Now's the time for announcements. Okay, next week we have Jim Love, who's sitting here someplace. He's sitting right there, he's waved his hand. He's our speaker, he's gonna talk about end of the world. Ought to be a good speech. He's worked as an engineer and educator and publications in both fields, holding both a BS and an MS in physics from the University of Texas. He's discussed what, why, and how the five market, how free market capitalism is not, I can't read my own writing. Free market capitalism is our time has damaged not only the middle class, but the USA's security as well. He will show how what includes major changes in the social and economic landscape of the last 50 years, and the why and how explains motivation, the change that connects the dots and illustrates why so many are angry, frustrated, and disillusioned with the leadership in both parties. Jim will essentially be analytical, but will outline and explain the most prominent feature of today's political landscape, anger. So that should be next week, it should be good. Anyway, our speaker tonight is Professor Raymond Kessler. He retired, Department of Criminal Justice, and Sul Ross State University, Alpine, Texas. He's going to discuss how the U.S. Supreme Court decision in D.C. versus Heller, 2008, decided that the Second Amendment gives rights to individuals who are not members of a formal state militia. He will show how this was a correct decision and how this relates to being a curb to firearms and violence. So without further ado, please give a very, very warm welcome to Professor Raymond Kessler. It's all yours.
Thank you. First, I want to thank Tom and Jim for this opportunity, and secondly, thank all of you for coming. I've got a bad cold, so I'm going to apologize in advance if I sneeze or cough. I want to apologize in advance. I've got a bad cold, so I may cough and sneeze, but just ignore it. Okay, our two topics for tonight are what is the correct interpretation of the Second Amendment, and what are the implications of that interpretation for gun control laws. Part one will be a lot longer than part two. If you would like to comment on this presentation or something related to it, I've set up a thing on my blog where you can add your comments. The blog is called crimelawandjustice.blogspot.com. Now, I started studying the Second Amendment and gun control in the 70s when I was in law school. I took a course on civil liberties, but nothing was said about the Second Amendment. So I decided to do my own research, and I pretty much agreed with the consensus of the time was that it wasn't an individual right, and that massive gun control would probably be a good solution to the problem of gun crime. Over the years, my opinions have evolved after reading lots of materials, even publishing some stuff on gun control and the Second Amendment. I'd like to share with you my conclusions for tonight. I have joined two U.S. Supreme Court briefs on the Second Amendment, a brief in D.C. versus Heller and a brief in McDonald versus Chicago. I joined a brief for the Fifth Circuit in the case of United States versus Emerson. I'm also a history buff, which fits in very well with this particular topic. I try to maintain an open mind, and unlike many people, my view on the Second Amendment drives my attitude towards gun control rather than the other way around. Too many people decide on their gun control stand, then they manipulate their Second Amendment opinions to coordinate with that. I don't think that's the way to do it. But anyway, unfortunately, this is a complex topic. There is, unfortunately, no smoking gun. There are many ways to interpret many of the things that were written and were said. There are lots of good arguments on both sides. Reasonable people could disagree on what it means. And the Second Amendment is rather ambiguous because, number one, it's the only part of the Bill of Rights that has a prefatory clause or a prefix. And we were provided with a handout that gives you a wonderful definition of what the Second Amendment, what the Militia Clause is. But unfortunately, the Militia Clause does not control the second clause in the Second Amendment. It is by and large irrelevant to the interpretation of the right to keep and bear arms clause. But we will get into that later. Now, part of the confusion, as I mentioned, is the existence of the two clauses. Another source of confusion is that in the debates, there were a lot of issues that ran together and were treated together, making it difficult to sort them all out. And those three issues were standing armies, militias, and a right to keep and bear arms. And those, unfortunately, in a lot of the debates, those three separate topics sort of run together, and they do fit together, but they are, in fact, actually separate issues. If you have a copy of the Constitution, pull it out and we'll take a look at it. We'll be looking at some things. If you want to get into this, I suggest you get one of these little pocket copies of the U.S. Constitution. Some of them are free. You can get them. Now, I know probably some of you are really into this and some of you aren't, so it's very difficult to set up a presentation that everybody can comprehend, but I will do my best, and we will have questions, so I'll try to clarify things then. The basis of my presentation largely are the majority opinion in the District of Columbia versus Heller, which found an individual right, and the dissenting opinion of Justice Stevens, which held that it was not an individual right. I have compared those, and I feel that Scalia wins the contest. But I urge you to read those opinions. Go to District of Columbia versus Heller, read the majority opinion by Justice Scalia, read the dissenting opinion by Justice Stevens, see who you think has the best of the argument. If you do go to look at the opinions, be sure to read the syllabus for the opinion, and if you can, read the head notes, because there's a good preview. These opinions are not easy reading. In fact, when I talk to people about this topic, I say, well, have you read District of Columbia versus Heller? Well, some said, well, no, I haven't read it, but, you know, I read about it in the newspapers. Or some people said, I tried to read it, but I couldn't finish it. Well, if you really want an accurate view of history and what's going on, read original documents. Don't rely on what other people say those documents mean. Go look at them. And I'm going to be looking at some of these original documents. For instance, if you want to figure out what secession and the Civil War really were in Texas, go look at the Texas Declaration or Resolution of Secession. Then you'll find out what was going on. You don't have to believe the Board of Education or whatever your grandfather told you. Okay, obviously I joined a brief in the Heller case arguing for an individual right. But when the opinion came out, I spent a lot of time comparing the two opinions, checking secondary sources and checking original resources. I recently revisited that exercise, and did it again, and my conclusions are still the same. Both the dissent, which is Stevens, and the majority of Scalia agree on two things. Number one, they both agree that originalism is the appropriate methodology for solving the puzzle. Now, originalism basically has a number of forms, but originalism basically means that we look at what did this mean to the people who voted on it at the time? What did the words mean at the time? They also agree that the Second Amendment is a pre-existing right. And that's something that we will talk about because I think that's part of the problem of why this is a difficult topic. Now, part of the problem we have in interpreting legal documents like this is that people tend to support them not necessarily for the same reasons. Different people may have different reasons for supporting or opposing something. So it makes the interpretation of the materials difficult, but we'll do the best that we can. Now, over time, three models or three theories of the Second Amendment have evolved. The first we call the states' rights or the collective rights view. In this view, the Second Amendment is the right of the states to arm their militias. The word people in the Second Amendment means the people collectively as represented by their state government. Well-regulated militia obviously means the well-regulated militias of state governments. Now, if this is the correct interpretation, there is no individual right of any kind to have firearms. There is some evidence that this particular view arose after the Civil War and was, shall we say, fabricated by those people who were afraid that black people might start getting guns if they had Second Amendment rights. The second opinion we call the sophisticated collective rights model. For a while early on, the collective rights model dominated, but then people began to do research and they said, I'm just not buying it that the word people in the Second Amendment means states, and we'll talk about that in a minute. It just didn't make any sense. So they came up with what we call the sophisticated collective rights. Under this view, only members of formal state militias have an individual right to keep and bear arms. This is the view that's adopted by Justice Stevens in the Heller dissent, and I will be talking about that. The final model is the individual rights model. This is probably the newest model, but in my opinion, it's the most correct model for two reasons which we'll talk about. Number one, the prefatory clause in the Second Amendment does not control the operative clause. I'll explain that. And second of all, the Bill of Rights creates pre-existing rights. Doesn't create them, it protects pre-existing rights. So you have to look at history to figure out what do we mean by pre-existing rights and what was that pre-existing right. Okay, so let's get into it. First, let's take a look at the amendment, and you've got the handout here, which conveniently has it. You notice it has two clauses. First clause we call the prefatory clause, or the preamble, and the second clause is the operative clause. Now, the Second Amendment, like everything in the Bill of Rights, was drafted mostly by lawyers. And they knew they were drafting a legal document. And when you draft a legal document, a piece of legislation or a constitution, there are what are called rules of construction. That is, how is this to be interpreted? What are the rules by which we should be writing legal documents. And at that time, and probably still is, the rule of construction of legal documents was that prefatory clauses do not control or limit operative clauses unless the operative clauses are ambiguous. Okay? And that, in my opinion, is the problem with this handout, because the handout has to deal with the prefatory clause, but the prefatory clause doesn't. Oh, I'm sorry. Okay. The Second Amendment says, a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Okay, the prefatory clause is the militia clause, and the operative clause is the right of the people clause. So those are the two clauses. Much of the confusion has been caused because people assume that the prefatory clause controls the operative clause. But under the rules of construction at that time, it didn't. Now we'll look at the Second Amendment, and I think we'll find that it isn't ambiguous. In fact, the Supreme Court has never said anything in the Bill of Rights is ambiguous. And when you look at it, I don't think it is ambiguous. Now, Justice Stevens tries to create ambiguity in his dissenting opinion so he can enforce the prefatory clause on it, but I don't think that's a valid approach. Okay, so let's take a look at what it actually says versus those three models. If the collective rights model is the correct answer, the Second Amendment ought to talk about the right of the states to arm their militias shall not be infringed. But that's not what it says. If the sophisticated collective rights model is accurate, then the Second Amendment ought to say the right of state militia members to keep and bear arms shall not be infringed. What it says is the right of the people to keep and bear arms shall not be infringed, and that's consistent with the individual rights model. It's not consistent with any other models. If it meant what the other models said, why doesn't it say it? Also, we need to look at the Bill of Rights. The Second Amendment is a part of a relatively short document that we know as the Bill of Rights. And let's take a look at the language that is used in other portions of the Bill of Rights. First Amendment says, Congress shall make no law abridging the right of the people peaceably to assemble and to petition the government for redress of grievances. Second Amendment, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Fourth Amendment, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. Ninth Amendment, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. 10th Amendment, the powers not delegated to the United States by the Constitution, nor prohibited to it by the states, are reserved to the states respectively or to the people. Now you notice that all three terms, militia, states, and people, are used in this document. Does it make sense to say that the word people in the First Amendment, the Second Amendment, the Fourth Amendment means the government collectively? Does it mean states? No, they use the word states. So collective rights approach is clearly wrong, and people realize that fairly early on. That's why it was basically discarded. So we have three terms. Second Amendment talks about the militia, and then it talks about the state, and then it says people. Well, the Second Amendment uses the word militia, and it uses the word state, and uses the word people. If people equals militia, why don't you just say militia? If people equals the state, why don't you just say state? But it doesn't, okay? Do states have a right for freedom of speech? Do states have a right to be free of unreasonable searches and seizures? No. People have a right to freedom of speech and be free of unreasonable searches and seizures. Does the word people anywhere in the Bill of Rights mean the militia? No, it doesn't mean it anywhere. Does only the militia have Fourth Amendment rights? Does only the militia have First Amendment rights? No. So it doesn't make any sense in terms of the usage of the words in the Bill of Rights, which was a small document. And let's look at the word people, because that's one of the key issues. In a 1990 case called United States versus Verdugo Urquidez, Supreme Court says the Second Amendment protects the right of the people to keep and bear arms. And the Ninth and Tenth Amendments provide that certain rights and powers are retained by and reserved to the people. While this textual exegesis is no means conclusive, it suggests that the people protected by the Fourth Amendment and the First and Second Amendments, and to whom the rights and powers are reserved in the Ninth and Tenth Amendments, refer to a class of persons who are part of a national community or who have otherwise developed sufficient connection with this country to be considered part of that community. Okay, so people does not mean the states. People does not mean militias. Now let's just take one example. Let's talk about one group in the people. That's women. Okay, do women have First Amendment rights? Yeah. Do women have Fourth Amendment rights? Yeah. Do women have Second Amendment rights? Yeah. But women could back then, women could not be in the militia. Women couldn't be a lot of things back then, but one of them for sure, the law said they couldn't be in the militia. So to define the word people to mean anything other than individual people doesn't make any sense. Another thing you need to notice about the Bill of Rights is that it doesn't say the people shall have a right of freedom of speech and press. It doesn't say the people shall have a right to be free of unreasonable searches and seizures. It says the people shall have a right to freedom of speech. Okay? The people shall have a right to keep and bear arms. The Bill of Rights doesn't create any rights. All it does is recognizes pre-existing rights. It says the right of the people. Okay, it doesn't say the people shall have a right. It says the right of the people. I mean, that means it already exists. We're not creating it. Okay, let's talk a little bit about natural law theory, because this is where this idea of pre-existing rights comes from. Most people aren't familiar with natural law theory because it was big in the 1700s and the 1800s, but we've moved away from that. But it is part of the philosophy of the founding of our country. The Declaration of Independence says, "We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain inalienable rights, that among these are life, liberty, and the pursuit of happiness." Later on in the Declaration of Independence, it says that the revolution is necessary so the people of the United States can assume the separate and equal station to which the laws of nature and nature's God entitle them. The idea of natural rights is also found in the Ninth Amendment to the Constitution. It says, "The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people." So what it says is just because we've listed some here doesn't mean that you don't have other ones that we haven't listed. And what are those other ones? Well, those are natural law rights. Now, we were talking about pre-existing natural law rights. In 1897, in a case called Robertson versus Baldwin, the Supreme Court said, "The law is perfectly well settled that the first 10 amendments to the Constitution, commonly known as the Bill of Rights, were not intended to lay down any novel principles of government, but simply to embody certain guarantees and immunities which we had inherited from our English ancestors." In a 1876 case called United States versus Cruikshank, where it's about the Second Amendment, but the court never got to what the amendment mean. The defendants were blacks who had been disarmed by the Ku Klux Klan, and they filed charges against the Klan. The charges were ultimately thrown out. The court says the right there specified, talking about the Second Amendment, is that of bearing arms for a lawful purpose. Notice it says the right there specified is the right of bearing arms for a lawful purpose. It doesn't say the right of bearing arms in the militia. This is not a right granted by the Constitution. Neither is it in any manner dependent upon that instrument for its existence. The Second Amendment declares that it shall not be infringed, but this, as has been seen, means no more than that it shall not be infringed by Congress. This is one of the amendments that has no other effect than to restrict the powers of the national government. Remember that, as originally enacted, the Bill of Rights only limited the federal government. It wasn't until much later that most of the Bill of Rights became applicable against the states. And the Second Amendment is one of those rights that has become applicable against the states, and that was in the United States Supreme Court's decision in Chicago versus McDonald in 2010. In Cruikshank, they said, states, we said, were free to restrict or protect the right under their police powers. There was no claim in Cruikshank that the victims were members of a militia or were participating in militia activities. Indeed, the governor had abolished the local militia a year before the incident occurred. And the court says, we describe the right protected by the Second Amendment as a right of bearing arms for a lawful purpose, and said that the people must look for their protection against any violation by their fellow citizens of the rights it recognizes to the state police power. Okay, Supreme Court says Second Amendment right is a right of bearing arms for a lawful purpose. It doesn't say bearing arms for a militia, it says bearing arms for a lawful purpose. Now, what is this right that is codified by the Second Amendment, and how do we figure out what it is? Well, we know it's a natural law right. We know it's one that comes from our English history. Okay, the colonists thought they were entitled to all the common law and natural law rights that other Englishmen were getting, and they were ticked off because they didn't think they were getting them. Now, so how do we figure out what are pre-existing rights? Well, if you want to learn something about the common law of England before the Revolution, you go to a book called Blackstone's Commentaries. Blackstone's Commentaries was the one legal book you better have if you were a lawyer back then. And you better have it if you're a politician or you want to write laws. Okay, this is the authoritative book about the English common law and the rights of Englishmen. Now, what did Blackstone write? This is from Book the First, The Rights of Persons, Chapter of the First of the Absolute Rights of Individuals. Now, this is number 5, and I'll explain what it means later. Quotes, "The fifth and last auxiliary right of the subject that I shall at present mention is that of having arms for their defense suitable to their condition and degree, and such as are allowed by law, which is also declared by the same statutes, which is the English Bill of Rights." Now you notice that they're not saying that the right to keep and bear arms is absolute. They're saying that it is subject to regulation. But that'll be an important point later on. Now, Blackstone goes on to say that this right is indeed a public allowance under due restrictions of the natural right of resistance and self-preservation. Okay, John Locke, who was one of the inspirations for the Founding Fathers, said that self-defense is the first law of nature. Now, what do we mean by an auxiliary right? An auxiliary right is a right that you have to have so you can exercise another right. If you are going to exercise the right of self-defense, you have to have access to weapons if you're going to defend yourself. If you don't have access to weapons, you bad guys are going to have weapons. They aren't going to follow the law. So if you're going to have a right to self-defense, you have to have a right of access to weapons. Now, there are 5 auxiliary rights. We won't get into this, but the first one is a person has a right not to be detained or imprisoned except pursuant to legal authority, and the right to habeas corpus. That was incorporated into the Fifth Amendment right of due process and the habeas corpus clause in the Constitution. You have a right to reside in the nation and not be exiled except pursuant to legal authority, which is basically the due process clause, which says in the Fifth Amendment, Bill of Rights, no person shall be deprived of life, liberty, or property without due process of law. The third auxiliary right is the right of access to courts to protect those rights. It's nice to say, well, you got all these rights, but, prove it. Well, that's what courts are for. And that's something that's also included in Fifth Amendment due process. The fourth auxiliary right is the right to petition King and Parliament for redress of grievances or when rights are violated. And that's in the First Amendment. So basically, you can see there's a lot of Blackstone and the English Bill of Rights, which we'll talk about in a minute, in the Bill of Rights and the Second Amendment. Okay, the other main document, the one that's cited by Blackstone, originally written in the 1760s, is the English Bill of Rights of 1689. Now, if you go look at that, it says nothing in there about a right of militia members to have weapons. It says nothing in there about the right of states to arm their militias. It does complain about a standing army, which the colonists complained about too. And it does complain about arms. It says they complain of the king that the subjects which are Protestants may have arms for their defense suitable to their use, conditions, and as allowed by law. Now, why are they mentioning Protestants here? Well, because at that time England had a Catholic king, and he tried to disarm the Protestants, and the Protestants said, you're taking away our natural law right to have arms for our defense, and you're allowing the Catholics to arm, and that's a violation of our rights. Now, Stevens says that Blackstone and the English Bill of Rights are irrelevant to pre-existing rights. Well, I don't think you'll find any reputable historians who will agree with that, or any philosophers. It's just the way it is. Another source that we can look at to figure out what it means is the state constitutional rights, state constitutional Bill of Rights that were enacted a little before, a little after the Bill of Rights. Now, unfortunately, there isn't much consistency. Some say people have a right to keep and bear arms in the defense of the state, and that's talking about a militia. Some of the provisions say in defense of themselves and the state, which suggests both militia and individuals. However, if you look at the 9 that are closest in time to the Bill of Rights, 7 include an individual right. So the overwhelming majority of state constitutional rights provisions at that time include an individual right. Now, we have a problem here because why didn't they say that? Well, part of the problem we have in interpreting what other people are saying and doing from 200 years ago is that certain things are obvious to them and they don't need to be said. But 200 years later, they aren't obvious anymore. It was why spend time talking about something that everybody knows and agrees with? And that's what makes the interpretation of historical legal documents difficult, because you have to understand the assumptions that these writers were coming from. And those assumptions are natural rights law, Blackstone, English Bill of Rights. Another important thing that happened is while they were drafting the Bill of Rights, there was a proposal made to add the words "in defense of the state" to the end of the Second Amendment. Now if that was in there, that would sound, well, we're talking here about a militia. But that was defeated. That was not added to the Bill of Rights in spite of being proposed. And I think that's pretty important. Let's talk about one more case. Justice Scalia talks a lot more about the case law before the Miller case, which we'll talk about, than Stevens does, because Stevens doesn't have a lot of support. You're probably familiar with the infamous Dred Scott decision. The opinion of the court was that black people don't have the rights of other people because they're not citizens. Black people can't be citizens, according to Dred Scott. Even if you're a free black person, you can't be a citizen. And the Supreme Court wrote, if black people were citizens, it would give to persons of the Negro race who were recognized as citizens in any one state of the Union the right to keep and bear arms wherever they went. Back in 1857, there were no blacks, free or slave, in militias. And it also says wherever they went. So I think clearly the implication from Dred Scott is that we're talking about an individual right. Now, prior to the Heller case in 2008, there was only one case that really attempted to delve into the meaning of the Second Amendment. That was a 1939 case, United States versus Militia. It's a very unusual case. We can talk about it if you want to, but I'm just going to hit you the high points. In the Miller case, the Supreme Court issued an opinion which seems to be supportive of the collective rights approach. In the majority opinion, Justice Scalia does not overrule explicitly the Miller case. He finesses it, and not, in my opinion, not in a very convincing fashion. But the conservatives on the court hate to overrule precedents. The liberals on the court love it. I mean, they just love taking the machete to the precedent. But the conservatives, especially Chief Justice Roberts, they don't like rocking the boat. They want to look like the Supreme Court is a stable institution and has respect for precedent. Well, in the real world of the Supreme Court, precedent has very little effect. there have been a couple of empirical studies done that show that precedent has really no impact on decisions. Why? Because justices who don't like the precedent figure out some way to get around it. And the justices who do like the precedent yell and scream that, oh my God, they're overruling this. So precedent is one of those things that's one of these things like the Supreme Court like it says, well, we're controlled by precedent. Well, they aren't controlled by precedent. They're at the top of the judicial heap. They don't answer to anybody. They don't have to follow precedent, and they don't. And following precedent is not necessarily a good idea. Okay, it took the Supreme Court 1954 in Brown versus Board of Education to overrule Plessy versus Ferguson. And I'm sure people screamed, no, you're not following the precedents when the Supreme Court announced Brown versus Board of Education. Now, again, part of the problem we have is that we don't understand where they were coming from back then. Remember that Declarations of Independence and Bill of Rights and many legal documents are also political statements. And then we have the question of, well, if the prefatory clause doesn't mean anything, why is it in there? Okay? Now, if you're into U.S. history, you know about the Federalists and the Anti-Federalists. Okay, the Federalists wanted the new Constitution to replace the Articles of Confederation. The Anti-Federalists didn't. The Anti-Federalists screamed there was no Bill of Rights, and some states even conditioned their ratification of the Constitution on addition of a later Bill of Rights. Now, the Bill of Rights was authored by James Madison, who was a Federalist. And originally, Madison said, we don't need a Bill of Rights. But the Anti-Federalists threatened to call a constitutional convention, and the Federalists were afraid that they would use that to defeat and change a lot of things in the Constitution. So Madison wanted to preempt the Anti-Federalists by getting his version of the Bill of Rights before Congress first, which he did. Now, why did they mention this militia in the opening part of the Second Amendment? Why? Because, number one, the Federalists saw the militia as a very important part of the system, and the militia would stand as the counterweight to the standing federal army, and in fact they had hoped that it would make a federal standing army unnecessary. And we know, as a matter of fact, that didn't work out that way. So Madison threw a bone to the Anti-Federalists and say, well, we'll throw this in here about how wonderful and important militias are. Maybe that'll get some of the Anti-Federalists off our back. Also, some of the Federalists were worried, and some of the Anti-Federalists were worried about the standing army and even the militia. If you look at the militia clauses in the Constitution, you'll find that basically the federal government has taken over state militias. The only thing state militias do is appoint the officers. And the federal government can call state militias into national service, and they are commanded by the president. Okay, that's in, I believe, Article 3. So the Anti-Federalists were worried that the president would nationalize, federalize the militias. Now, the president has the authority to have a militia serving outside its own state. And later on, the Supreme Court that said that the president has the right to make the National Guard, which is arguably the successor. He can send the National Guard overseas without any approval by the states. Now, to us today, this sounds a little paranoid, that the president would use the army to overtake the militias, overrun the militias. So the idea is that, well, if they've got the army, they nationalize the militias, send them to some of the state, who's going to be there to fight federal oppression? Well, it's going to be the people. But if the people don't have any guns, what are they going to do? So we have to give these people, these individuals, a right to keep and bear arms if the federal government uses the standing army and select militias and the federal control of the militias to take over the country. Now, it sounds paranoid today, but the anti-federalists were really into this, and some of them were a little paranoid, but that was an argument that they made. In fact, that's an argument that Madison addressed in one of the Federalist Papers. So it was a real deal, even though today it sounds a little far-fetched. Okay, so in my opinion, the Scalia opinion, majority opinion in District of Columbia versus Hill is clearly superior opinion. It is the strongest opinion. Justice Stevens presents no evidence from English history of there being a right of militia members to have arms. He presents no evidence from English history that states had a right to arm their militias, because there weren't states in England. There couldn't be any reference to it. He talks a lot about the debates over the Constitution and the Bill of Rights, but none of that has anything to do with pre-existing rights. Stevens has absolutely no relevant evidence of a pre-existing right of militia members to have arms. That's why his opinion fails. But read him yourself. Read Scalia's majority opinion. Read Stevens' dissenting opinion. Look at some of the original sources. Look at Blackstone. Look at the English Bill of Rights. Look at some of these original documents before you make up your own mind. Okay, now we got to move to issue number 2. Well, let me recommend a couple of readings. I'm a retired educator. If you're interested in a very good, readable, short book about the Second Amendment in the Heller case, there's a book called Gunfight by Adam Winkler, Winkler. Very short, very readable. I strongly recommend it. Now, if you really are a glutton for punishment and you want to dig in to see, well, what actually did the people write in the newspapers and then letters to the editor? What actually was said during the debates over the Constitution and the Bill of Rights? There's a very good book by David E. Young called The Origin of the Second Amendment. And he collects everything he could find dealing with militias and arms and the rights from back in that period. And his conclusion is the same as Scalia's. It's an individual right. Okay, issue number 2. The Second Amendment, like all rights, is not absolute. There is no constitutional right that you have that's absolute. Does freedom of speech give you the freedom to yell fire in a crowded theater? No. Does freedom of religion give you the right to have human sacrifices? No. No rights are absolute, and that's the problem many people fall into. They, wow, I got a right to freedom of speech, I can say what I want. I got freedom of religion, I can do whatever I want. It don't work like that. Now, in his opinion, Scalia talks about certain types of regulations that existed in the English common law and at the time of the founding of the Republic, that he says these are the exceptions to the right to keep and bear arms, which were recognized and accepted by the people at that time. These are presumptively constitutional. long-standing prohibitions on the possession of firearms by felons and the mentally ill. I don't think anybody has a problem with that. Second, laws forbidding the carrying of firearms in sensitive places such as schools and government buildings. I don't think most people have a problem with that. Am I running out of time?
No, I was just saying I do, but.
Okay, I'll be done here in a minute. There's also has no problem with laws imposing conditions and qualifications on the commercial sale of arms. I don't think most people have a problem with that. Now, another interesting issue is what kinds of arms are protected by the Second Amendment. Justice Scalia says, weapons in common use for lawful purposes are protected by the Second Amendment. Now, the hot buzzword in gun control now is assault weapon, okay? Are assault weapons in common use for lawful purposes? Yeah. In the 1990s, it was estimated that there are 3 million assault weapons have been purchased in the United States. Last year, the estimate had jumped up to 10 million. Many gun manufacturers report that assault weapon sales are their #1 selling item. In case you haven't noticed, anytime anybody talks about gun control, people run out in droves and buy guns. Well, you start talking about assault weapons, the New York Times ran an editorial saying that they should be banned and that people who own them should have to give them up. They don't give them up, we're gonna come and take them. How many people went out and bought assault rifles after they saw that New York Times editorial? A lot. So who knows how many we have? 12 million, 15 million assault rifles in the United States? You're going to ban those and take them away from how many million people? Sounds a little unreasonable to me. Now, that's about all the court said about what kind of gun regulations are permissible. There may be others. But the important point is that it's not an absolute right. Okay, that's it. Okay.
Who wants to be first?
Looking at this Second Amendment, there appears to be 3 commas in the single sentence. Is that correct?
Appears to be what?
3 commas.
Well, the commas aren't really important. In fact,
Oh,
some
yes, they are.
well, no, they aren't, because they're in the different drafts of the Second Amendment, they changed the commas around.
Well,
The one that was written by Madison is not the same as the one that was
Well-
adopted by Congress,
Well-
not the same that was voted on by
well,
the people.
the one that stands today, does
Uh-huh.
it have 3 commas?
Yeah,
Okay, thank you. Because we have 3 clauses actually.
Yeah.
So it's a matter of opinion as to what the subordinate clause is and the primary clause is in my
Yeah.
judgment. But, okay, I'll have more to say.
okay. Okay, I'm not sure what the point was, but you got to remember that the commas don't control how it's interpreted. The rules of construction control how it's interpreted.
Okay, you're a former educator.
Yeah,
I'm a current educator.
okay.
I just wonder what your opinion is of the campus carry law that's going to go into effect shortly, or I think has already at the big universities and will at the community colleges in 20.
I think it's largely a tempest in the teapot. You're already, under current law, before they added this, you were allowed to bring your weapons on campus in your car as long as you didn't go into buildings. Did you see a lot of mass shootings on campuses because people were allowed to bring guns into campus in their cars, and the only place they couldn't take them was into buildings? No, you didn't see that. What you see is a lot of paranoia by college professors who don't trust their own students.
Do they have a reason for that?
I don't believe they do, no. I've been teaching in higher education for over 30 years. I taught in West Texas where everybody has a gun and everybody's pickup has a gun in it, maybe 2, 3, 4, I don't know. I was a very tough professor. I had a lot of students who didn't like me. Did I ever feel threatened? No.
Speaking of history, when we go back in our memory, the last few decades, maybe 4 decades back or so, the first occurrence we began to have of these mass shootings spawned a phrase going postal.
Yes.
Now, do you have an opinion on how that came about and whether the fact that postal facilities were gun-free zones, if that had anything to do with it?
Well, there was a postal employee who went bananas, killed a bunch of his coworkers. If you're a criminal, do you really care whether it's not someplace is a gun-free zone or not? Nah. If you're an law-abiding citizen, do you care? Yeah, because you wanna follow the law.
I want to go back to the paranoia of some college professors
Yes.
that you mentioned a moment ago. Okay, why would you say that college professors are being paranoid and not wanting guns on college campuses, but members of the United States Congress are not also being paranoid by wanting citizens to carry guns into the United States Capitol?
Well, number one, you may have noticed there's a lot of hypocrisy in Washington, D.C., so that might help explain it. There was an attack in Congress in the 50s by Puerto Rican nationalists.
Well, there have been several attacks on college campuses.
Sure, there have been several attacks on college campuses, but you may remember that in his opinion, Justice Scalia said there are certain types of places where guns can be prohibited. I think he would probably agree that Congress is one of those places.
Not if they're going to demand that colleges and universities have to allow guns.
Right, but that's legally irrelevant.
Huh?
It's legally irrelevant.
Right, so they get to call the shots for themselves and protect themselves.
They have always been calling the shots, and they have always been protecting themselves. Doesn't make it right, but that's the reality.
Yeah, but you characterize the college professors as
Yeah.
being paranoid.
Yes.
And yet you want to claim that the Congress is completely justified in their paranoia, but college
Okay,
professors aren't.
if it will make you happy, Congress is paranoid.
I'm just pointing out the inconsistency, and you're ridiculing me for it.
Okay, I'm just telling you the way I see it.
Okay, I want to make a statement and then I want to ask a question. One is former professor of A&M, guns are next to their heart. The Bible and the gun lay side by side. And as one at Sul Ross, for like you, everybody had a gun in the back of their pickup, including me. So, yes, there is that issue that they don't like your grade, thought crosses your mind. Are we gonna shoot it out or are we gonna talk it out?
Well,
But universities, I never felt endangered by the guns that were there, nor did my students feel endangered by my gun.
okay, I agree. I never felt endangered any, and I wasn't the most popular person on campus.
I was. I held a gun on them until they said I was. But my other question is, these people who have come to protest the Bureau of Land Management for the 2 ranchers and have gathered from all over the United States. The ranchers do not know them, and they are heavily armed. What is the issue there? Who has the authority to say they cannot come and be armed to protect that Bureau of Land, that particular property?
Well-
That bothers me because we have a lot of that kind of property here in Texas.
Well, the place that they are occupying is a federal facility. So I would think that the federal government can make a decision whether or not carrying arms was lawful there. It might not be constitutional or not. If you check out my blog, I've got an article on that on my blog. What's behind it? Anytime you give people rights, other people are gonna abuse it. Okay, just go on the internet and you'll see all sorts of trash, pornography, and who knows what. Well, why? That's the price we pay for having freedom of speech. A lot of people don't like hate speech, but that's the price we pay for having freedom of speech. Rights are not free. There's always a social cost. If there wasn't a social cost, nobody would have bothered to make it a right in the first place, because those who are concerned about the social cost would be crunching on those rights. So yeah, there's gonna be people who are gonna abuse their Second Amendment rights, just like there's people who abuse their First Amendment rights and who knows what else. That's just the way human nature is, unfortunately.
So they can legally be there?
I'm not sure that they can. But I seem to recall that there was a federal statute which said if you had a concealed carry license, you could carry in national parks. I don't know what the statute says about this particular place in Oregon.
I'm curious if you've read and studied any of the Dick Act in regards to weapons.
Any of the what?
It's called the Dick Act.
Yes, I'm familiar with the Dick Act, 1903.
Right. And how that impacts our rights today.
Well, the Dick Act was passed, created the National Guard because the militia system was obviously failing. The states weren't keeping them up. They weren't abiding by the federal militia statutes of 1791, 1792. The feds finally got fed up and said, we need some kind of reliable organization here because the state militias are a disaster. So they created the National Guard. I'm not sure what it has to do with the right to keep and bear arms.
Parity with the military. In other words, weapons that would be on par with military weapons.
Okay.
That was in the Dick Act. Is what
Oh,
I'm saying.
okay.
People have the right to carry and have any weapon that the military has.
Well, that's in a statute. That's not in the Constitution. Well, most people have never even heard of the Dick Act. They wouldn't know where to find a copy of it, if they wanted to. So I see it largely as irrelevant.
I have a couple of questions. First, if someone were to break into this restaurant and start shooting people tonight, would you want people in here to have weapons?
Yes.
I think I would too. And I think in any of those theaters and schools, if there had been armed people, the casualties would have been far less.
It's possible, yes.
And we live in a world, I believe, that we cannot just be sweet about it and say, let's take away all the weapons, because criminals will always have weapons.
That's correct.
Now, I remember reading a few years ago that Obama, before he became president and afterwards, stated that he wished to have a private military under his control, greater than the United States military. How does this fit with the Constitution?
Well, assuming that's true, and I can't ever say that I've seen an original document that said, but I do remember seeing something like that in the newspaper. Well, the president is commander-in-chief of the armed forces. Can he create special units? Probably, yeah. Does he need congressional authorization for that? Probably not within limits. But remember, the Constitution says that standing armies shall not be funded for more than 2 years. So even if he did that, hopefully Congress would catch on and shut off the money. But if he really proposed that, I would be very concerned, yes.
Does this seem sort of parallel to the Nazi SS?
Well, that may be a little overdrawn because we don't know what he intends to do with this.
Hello. Is it true that Oklahoma has had open carry forever and nobody even knows?
I don't know. I'm sorry.
No, you don't know either. That's what I heard. I heard they had open carry and you go up there and you never even see a gun. Like, if you go to Tulsa or into the city.
Well, there is a state in New England, I can't remember whether it's Vermont or New Hampshire, where you can open carry or concealed carry without any kind of license. Vermont?
I have heard or read someplace that there is a state statute, and I wonder if you know what the statute is in Texas. It defines the National Guard, the State Guard, and that everybody else is the militia.
Yes, that's correct, yeah. It's called the Texas State Guard, yeah.
But then everybody, if you're not a member of the National Guard or the State Guard, then you are automatically a member of the militia.
Well, there's a federal statute from 1791 and 1992, which is still in effect, which says that everybody, now includes females between 18 and 45, is a member of the militia of the United States. But check the Federal Militia Act 1791, 1792. So maybe technically that's still correct.
Another question, if it is not allowed, if prohibiting people who have mental defects from owning guns is the law, if there are people that prevent that information or hide it, and that person commits a crime, does the person who prevents that information from getting into the public stream guilty also?
Well, you'd have to see whether there's a statute making it a crime. I mean, we don't have common law crimes in this country. There has to be a statute. There's no statute that says it's a crime, it's not a crime.
Well, if the statute says that it is a crime for a felon to own a gun, or someone with a mental defect to own a gun,
Yes.
and then there's another profession, usually referred to as mental health providers, who has this information and then prevents it from getting in the public domain or to the authorities, and this person commits a crime, would they have some culpability?
Well,
the mental health profession.
Well, I don't know about as a mental health professional, but you might argue that they're an accomplice to this illegal firearms transfer, which if you're an accomplice to a crime, you can be punished for the crime. But I don't know if accomplice liability applies to that kind of crime. So,
Amen. If a school, last question, all right. If we have the right to carry arms, open carry in Texas, and then a university decides they want to prohibit them being carried in a classroom or a dormitory, would it then be reasonable to require that they take out financial liability insurance, just like someone who drives a car in case there is an incident in there and someone can't protect themselves and they subsequently get injured or die?
well, if it negatively impacts the right to purchase firearms or to carry firearms, you can argue it might be unconstitutional to require that.
But they're doing that already. I mean, that's what they're doing. They're trying to say you can't take them in a classroom, you can't take them in a dormitory. Well,
Sounds like a good idea to me.
That sounds like that's a de facto prohibiting of guns.
Well, I don't think that the legislation that the legislature passed would allow that.
That's different.
No, it's not. Depends on whether you own the living room or the campus. It'd be nice if this run by.
As a mental health professional, we're governed by the mental health statutes, of course, and there is such a thing as a duty to warn. So there would be a duty to warn of, let's say, anything that was said by a patient that would involve harm to other people. It's called a duty to warn.
Well, theoretically, the legislature could pass the statute saying that it's a crime if a professional doesn't meet their professional responsibilities.
Right.
There might also be tort liability on the civil side,
Yes.
but I really don't know that much
Yeah.
about that.
Are we at the end of the questions?
I'm just curious where the buck finally stops as far as the interpretation of our Constitution. It seems that our great leaders in power think it's a living document that is open to interpretation depending on what they want to implement. Where does the buck stop? Does the president have the power to overrule the Supreme Court with his interpretation?
or is it just merely the Supreme Justice?
No, the president can't overrule the Supreme Court. Now, presidents have bucked the Supreme Court, in my opinion, illegally, but they don't have the Supreme Court has the final say of what the Constitution means.
So the president doesn't have that right. Does General Electric or Raytheon have that right to overrule the Supreme Court?
Do they have the right?
To overrule the Supreme Court?
No, they shouldn't have.
My understanding is that private colleges in Texas have the right to opt out from open carry. Am I correct with that?
Yes.
Right. I do know for sure that SMU has opted out, and this was not only the majority of their faculty, but it was also the majority of their students. I think the same is true for TCU. I don't know about other schools, but my reading of newspaper tells me that generally speaking, private schools are opting out, and it's a majority of students and a majority of the faculty. And my question to you, are all these people paranoid?
I would say they're not all paranoid. Unfortunately, what you'll find is that most large college campuses and universities lean left. The faculty leans left, and they bring the students with them. But you got to remember that in addition to our constitutional right to keep and bear arms, there's a constitutional right of property. That was one of the main natural law rights: life, liberty, and property. So if your property right gives you the right to keep people from coming on your property with guns.
I want to get this straight. SMU leans left in the heart of the Park City.
I'm not saying SMU. I'm saying most universities lean left.
Yeah, the faculty, I'm an alumni there, left-leaning faculty, and they have a lot of students from up north who have, as Professor Kingsfield once observed, heads full of mush. They haven't grown up yet. My question would be this: if a university, because it's a private institution, can disenfranchise people on their campus from an established constitutional right like open carry, can they also disenfranchise people from other constitutional rights, such as freedom of speech, freedom of religion, Fourth Amendment rights against protection, et cetera, et cetera?
Okay. In general, yes, but this is what you got to keep in mind. The Bill of Rights and most of the amendments to the Constitution only limit the powers of government. They do not limit the powers of private property owners, private corporations, private universities. The only rights amendment that applies against everybody is the 13th Amendment ban on slavery. The Due Process Clause says no state shall make any law depriving people. There has to be government action before there can be a violation of a constitutional right.
Yes, in our founding fathers setting up the acknowledgement of these rights, do you think that they were predominantly more focused on the people protecting themselves from random criminals, or protecting themselves from a rogue government that is attempting a police state?
Well, they were more interested in controlling the federal government and defining the powers of government and the relationship between states and the federal government. They weren't really interested in crime. At that point, crime was not a federal issue. There were little or no federal criminal statutes back then.
Just very quickly, you acknowledge that the firearms can be regulated. What is the limit of that regulation? For example, can the government require a database into which all firearms are entered with their serial number and that kind of thing?
I would say possibly they could. Now, you also have to realize that people have privacy rights, and those databases may violate those privacy rights. So, problem is that much gun control involves other constitutional rights, not just the Second Amendment. If you're going to confiscate firearms from people, you're going to get in their houses with search warrants. You may have to use force. So then it implicates the Fourth Amendment. So there's a lot of rights that may be involved beyond just the Second Amendment in some of these proposals.
You get to sit down now.
Okay.
Okay, now we have time for rebuttal. Anybody who wants to be first? Yeah, you can sit down here somewhere. You're first.
Oh, boy, this is such a hot topic, I wanted to talk. Thank you, that was quite erudite. I want to start by saying that I agree with his conclusion, but I completely disagree with the angle that he comes from. Not that it's necessarily wrong, but maybe something I have to say will resonate with some of us out here who aren't legal scholars. The question that is facing us, and I think most of us realize this now, is what is America? What does it mean to be an American? What does it mean to be a world citizen? How do they overlap? Well, this has a lot to do with it. There's a view that's usually not too thought out, that if you go along, if you're law and order, and you go along with the common order of things, you're a good citizen. Well, this only goes so far in times when corruption is becoming exposed so much. Now, as far as my difference with the presenter, and I got to respect what he can do. I could never do anything like that. I don't know what he knows. The difference is this. He seems to worship the book. It's in the Constitution. It's in Blackstone's. And this stuff is hundreds of years old. And although I agree with his conclusion, I'm going to try to explain within less than 5 minutes why I come from a different angle. I still agree. The Constitution, let's start with that. To me, that was a brilliant step forward for mankind. And we see people coming from all over the world here. We have riches, we have happiness, we have freedom. People come from all over the world. Still, they come over here. And I think this stems from our Bill of Rights. Let's forget about the Constitution altogether, but the Bill of Rights especially. And our freedom, and our wealth is the main thing. Our wealth attracts people, and our freedom. And the Bill of Rights had our freedom protected, and this was kind of known as the place where government by the people, for the people. What was the other one? Against the people? Huh? Of the people. Of the people. Well, we don't know what the people are anymore. Now we got protected groups, and we got everything. My point is this. The government is maybe always has been more like a gang than we like to realize, because it's so sophisticated and so large, and it uses fancy words and uses pens and paper to rob us more often than the gun. But it has the gun. Now, you anti-gun people are forgetting who has the most guns, the military and the police. But you're saying they would never, never use it against us. Well, I think the question is, who is it in the beginning? What does it mean to be a world citizen, an American? Does it mean to just follow whatever somebody says that the UN Council said, or the President said, or the Congress said, or the Constitution said? I think, to me, the primary thing now is the spirit of revolution that this country was founded in. It wasn't founded in empire. We were the anti-empire people. Now, we are the empire. Now, the mainstream news is so full of lies, it's insane. But the worst lies that I see are coming from all our officials, from the policemen on up to the president, who swear on that Constitution. Now, I'm saying, on one side of my mouth, I'm saying the Constitution is not like the Word of God where, you can't even question it at all. But I think it's very good and very brilliant. However, the people who swear they're going to defend it are the most blatant offenders of breaking the Constitution. There was a time, not too long ago, with any of that stuff that Obama or Bush or Hillary Clinton have done, it would have got them thrown out. They would have got hung up, probably thrown in jail, maybe killed. Now we have been conditioned to accept lies, lies, secrecy, lies. Secrecy and lies and war. 1, 2, 3. There they go. And so here's the deal. If you think that government is really your daddy and loves you, you should have gun control. If you think that you're a person, a citizen, and your duty and right is to be an adult, then you need to think more and not look at all the mainstream stuff. And I noticed that it's working. A lot of people are developing a religious, like, kind of a psychological revulsion to guns, guns. Now you realize most of these big mass shooting events they're using are part of a program to push us. They're false flags. 911 was a false flag. Oklahoma City was a false flag. A lot of this stuff, like the shooting in Aurora, very questionable. What happened in Sandy Hook? It's against the, you know, the question is like, oh, it's too horrible. So if it's really, really horrible, then we don't question it. Well, that's the things we have to question. That's what's called being an adult. If something really horrible happens to my kids in my house, I don't go running away in the corner and start watching TV. I go right to it. Hey, Cornelia, I can hear him too. Anyway, so that's the question. Do we have what it takes to grow up and break our conditioning? I've said this before, we're like the boiling frogs. They slowly take away our rights. They slowly move over what's normal. Like, things that we put up with now are so absurd. If they was given to us suddenly, we wouldn't have taken it. So they've moved us way over, and now they say, look over here in Iraq, in Iran, everywhere is much worse. You don't want to be like that. Look how lucky you are. Well, yes, that's true. We are comfortable and rich and safe, but we're like the sheep. So we give up our rights. A lot of our other Bill of Rights are going to go. The Second Amendment holds a lot of us together. So that's why I do agree with him. I don't agree with the approach of referring to a book, mostly because I don't know that much about the books, but I don't respect them. I'm not a book person. I don't swear by any particular Bible, even the Constitution. But anyway, so that's why my reasons.
I think it would make hunting a lot more interesting if the animals were also armed. Okay, first of all, I have to say that I agree with our speaker on some points and not on others. But first of all, let me tell you the one that I do disagree on is that the Constitution, or that none of the Constitution, I think he said this, that none of the Constitution is ambiguous. Well, I disagree fervently on that one. I think there's an awful lot of the Constitution that's ambiguous, especially the 9th Amendment, which says that any rights not specifically mentioned are protected. Well, again, what are those rights? They never said. We don't know. We're just expected to know that. Another thing I disagree with, and more importantly, is that the prefatory clause of the Second Amendment, I disagree that it's irrelevant and that it has no bearing on the operative clause. I do agree that people should read primary documents for themselves and not let other people interpret things for them. And so, for that reason, I have brought a primary document with me. Not long after the Second Amendment was ratified, the Congress of the United States passed the Militia, or the National Defense Act of 1792, which our speaker did mention briefly towards the end of his presentation. It was signed into law, of course, by, does anybody know who was president then? Here's the teacher in me coming out. In 1792, who was president? Jefferson. Are you kidding me? George Washington. Okay, the first one. Anyway, let me tell you why they passed the Militia Act. I have a newspaper article I'd like to read for you. It's just a short paragraph. It's from a newspaper that was printed around that time period. Standing armies, all admit, are inconsistent with the freedom of our institutions. We must, therefore, look to a well-regulated militia as our peculiar safety in war and in the important emergencies contemplated by the Federal Compact. The most efficient measures of organization and discipline in peace can alone render valuable this system of national defense. Now let me read you some of the, let me read you what it says. It was called the Militia of the National Defense Act. It was signed into law by President Washington on May the 8th, 1792. Section 1, be it enacted by the Senate and the House of Representatives of the United States of America and Congress assembled that each and every free, able-bodied white male citizen of the respective states resident therein who is or shall be of the age of 18 years and under the age of 45 years, except as is hereinafter accepted, shall severally, always trip over that word, and respectively be enrolled in the militia by the captain or commanding officer of the company within whose bounds such citizen shall reside, and that within 12 months after the passing of this act. And it shall at all times hereafter be the duty of such captain or commanding officer of a company to enroll every such citizen as aforesaid, and also those who shall from time to time arrive at the age of 18 years of age and under the age of 45 years, and shall without delay notify such citizen of such said enrollment by a proper non-commissioned officer of the company, by who such notice may be proved. And here's a really important part, that every citizen so enrolled shall, from and after he shall be duly notified of his enrollment, be constantly provided with a good musket or firelock. Musket or firelock. That's the only kind of guns they had back then, those muzzle-loading ones that took about a minute or two to fire one shot. Not like the weapons of today. A musket or firelock, a sufficient bayonet and belt, 2 spare flints, and a knapsack, a pouch with a box therein to contain not less than 24 cartridges suited to the bore of his musket or firelock, and a partridge in a pear tree. No, I added that last part. So, it seems to me, in light of the attitude of Americans towards standing armies, their feeling that the militia was the best way to go, the passage of a federal law requiring that every adult male within a certain age range perform a civic duty, much like we perform jury duty these days. Every male should have to perform a civic duty of militia duty. For that reason, I believe that the Second Amendment, as originally written with that prefatory clause, is absolutely a part of it. I don't think it's irrelevant. I don't think it's inoperative. I think it is very much operative. And I think that, we need to, if we're going to allow everybody to have any kind of weapon they want, then we need to rewrite the Second Amendment, because the way it's written now is not the way I think the founders, I don't think what we're doing now is what the founders intended. And to be honest with you, I wouldn't trust anything Justice Scalia was in favor of. Justice Scalia, in my opinion, is the worst justice on the court, with the exception of Clarence Thomas, perhaps. In any case, the Dred Scott decision, which was mentioned, was not only wrong about black people, it was also wrong about the Second Amendment. I think our state legislature was wrong about campus carry, too. I'm one of those paranoid professors. And as Forrest Gump says, that's all I have to say about that.
Well, thank you for the very informative last comment here. Now I know what I need. I need a 24-round clip. They don't make them, but I'm sure we could be accommodated if that's in fact the law, that everyone should be issued 24 rounds. But This gets back to a matter of culture. How do you speak to a modern audience about how things were 200 years ago? Everyone was armed back then. It was a gun culture. Now, what's really missing in all the debate about the Second Amendment today is the issue of a gun culture. The last legislation he was just mentioning about the militia really underlines it. Well, that implies training. We need training. When this country was founded, we had a phrase that turned up in fact, if you're going to pursue a case, you were sometimes considered a belligerent claimant of your rights. We think of belligerent now as a negative thing, but back in the day, that was considered the correct attitude if you were going to maintain your rights. Now, an interesting thing is we were talking about some of the amendments where the federal government begins to step in on the states. It's a very interesting thing that the 14th Amendment Equal Protection Clause actually gives us the ability to go to any state's law and use the best law we can find for our defense from that state's law, in our case, in our state, under the notice of foreign law. That this is actually used in court cases. Very ironically, and I've never heard anyone use this on a Second Amendment case. No one has ever invoked Vermont Carey and said notice of foreign law. I wonder why that is, because the 14th Amendment gives us that legal protection. One of the things that I run into here is why do people want the guns? Why? I mean, prohibition didn't work. Why do you want the guns? I have to, I discuss this with my liberal friends, and I've come to the conclusion that they're missing an important nerve, a nerve that would inform them of tyranny. Somehow or other, they don't have a super sensibility to tyranny, and maybe this is not exclusive to liberals. One thing that is not exclusive to liberals is authoritarianism. And I don't know sometimes whether some of my liberal friends are just simply naive about the Second Amendment and they believe that all we have to do is pass a law and that's going to correct everything, or whether they are closet authoritarians. And this is a big question. Why do you want everyone under your knuckle? Why do we have to have that jackboot on everybody's neck? The war for independence really has been mischaracterized in our history books. The war for independence was, in fact, a British Civil War. These are the British colonies, and they ended up breaking away from Britain. Why did they break away? Because of 600 to 800 years. I get the years mixed up now as far as how long it was, but going back even before Magna Carta, I think the treaties of 1100 are the guarantee of rights of one of the kings. The British people were basically promised or contracted with by their rulers that we will observe these rights. King George was not observing those with the colonies, and the colonies said, we're not going to put up with it. Now, to emphasize the authoritarian aspect, in February of 2004, I attended a Homeland Security meeting and heard the speech of a Colonel John R. Brinkerhoff, the author of the Rex 84 document that came to light during Ollie North hearings. And Brinkerhoff expressed in this public lecture that he believed that he needed 400,000 armed, trained, disciplined troops to, in the event of a catastrophic emergency, which could be anything from some major hurricane down to an economic downturn, to surround a metro area, quarantine it, and relocate everybody and deal with resistors very sternly. And he said 400,000 armed, disciplined, organized, and trained troops
to serve the policies of Homeland Security. Now, this is the mentality. This was a plans and policy man for FEMA. So if you're wondering where some of this craziness comes from, it's right out of the mouths of government people and policy setters. Colonel John R. Brinkerhoff, retired, and he said, it might take even 1 million troops, that we needed 1 million troops to pursue the policies of Homeland Security during a catastrophic emergency. And that means you cannot see to your own well-being at that point. You're going to have armed troops. And then he actually had a paper, he was very proud, he had put a position statement in front of Donald Rumsfeld. This was, again, back in 2004. And he said, I have Rumsfeld's ear. I wish he'd kept it. But he said, I have Rumsfeld's ear on this, is posse comitatus does not mean what it says, what people think it says. It says Congress cannot authorize troops use against the American people. He said, only the president can. The president can authorize troops against the American people. I think you need to look very carefully at some of the actions that have been taken. Mitch McConnell, recent legislation proposed. Thank you.
Well, thank you, Speaker. That was a very interesting and enlightening talk. I, of course, speak from a British viewpoint, as you might imagine. Yes, Blackstone is the founding book concerning common law. We still have common law, but it's moved on in the last few hundred years. We get by reasonably well without a constitution. In fact, I look at the Constitution in amazement. Apparently, as I said before here to this august body, America appears to have two constitutions, one for the Republicans and one for the Democrats. This is so, it must be true, because these decisions come down 5-4. And the 5-4 depending on the political persuasion of the justices. Had the illustrious George Bush II not been elected, we would have probably had a more liberal court, and the Citizens United decision would never have happened. Another gem of the Constitution was where the corporations were named as people, persons, in fact. Rather curious statement. And of course now, they have immense power because of the Citizens United decision to spend what they want. A clear violation of any notion of democracy, mind you. But there you are. Now, as I read this, the reason I asked about these commas is, in fact, this is a whole sentence. Now, when you have a primary clause and a secondary, we appear to have two secondary clauses. Now, as you should, if English is what I think it is, you could leave out the subordinate clause and it should still make sense. Well, this doesn't. Unless you could, well, let's leave out the two clauses, and you would read it like this: a well-regulated militia shall not be infringed. I mean, that doesn't make any sense. Now, so I think this was poorly written. You told us that lawyers carefully did this. Well, if they wanted people to have the right to bear arms, they should have said so. So really, looking at this, my judgment is this is meant really, you read it as a whole sentence. You can't have a first part and a second part as you implied. No, there are really three parts to this, because you have three commas. And therefore, you should read it as a whole sentence and not say, well, the first part is not relevant, and only the second part doesn't make sense. So, I mean, I don't have a great love of the Constitution. I think America would be better off without it, and does what England does, like every other Commonwealth country, have a parliamentary system and have a law that changes to suit the situation. As we do it, Australia does it, Canada does it, many other countries do it, most other countries do it. They do not have the American system. I mean, look at this farce with these gang of idiots parading around the country as pretend would-be presidents. I mean, goodness me.
Well, I really appreciate your presentation and the fact that you have gone into the legal aspects of it so well. And I think that's pretty well covered tonight. Looking at things practically speaking, it's just irrefutable that as you look through history and all around the world, those societies where the individuals bear arms have the lowest murder rates, and those societies where the individuals don't have arms have the highest murder rates. Specifically in Western Europe, Norway has the highest individual possession of weapons and the lowest murder rate. I think it is Belgium has the lowest possession of weapons and the highest murder rate. I think that a criminal who is going to break into someone's home or into a school or whatever, if he thought there was someone in there with a weapon, he'd think 2 or 3 times before he did that. And one example, a few months ago, there was some crazy man at a Walmart who pulled out a knife and just started randomly stabbing people. One man, exercising his right to carry, pulled out his weapon, stopped the guy, saved probably lives, certainly a lot of injuries, and had that criminal arrested. As far as muskets and assault weapons are concerned, muskets were the assault weapon of the period. They were the top military weapon. That was the intent of that, in my opinion. And I think that carries through to today with the increase of technology. We have in this country something that I think it is so easy to abandon and turn over to your loving politicians who say, oh yes, I really do agree with you on that issue. And they'll never vote for it the way you want. They just want your money. It is important that the people in this country exercise individual responsibility to monitor their government and control it. If we do not do that, we are going the way of fascism through socialism, and that is the fastest ticket to fascism. I think that you need to realize, I've mentioned this before, that the upper echelons of control in this world are largely very hidden from people, but largely satanic. They firmly believe in these things. Mark Passio, again, go on the YouTube and listen to some of his lectures. He was well into that in the Satan Church of America until he got out of it, realizing it was just violating the fundamental laws of morality of the universe. It's very pervasive, and the belief system involved in it creates the psychopath. And that's what we largely have in government. Homeland Security, this wonderful little statute that tracks a lot of what Hitler had passed in the 30s. The translation of Homeland Security into Russian is 3 words starting with the letters KGB. You think that's coincidence? I don't. In order to achieve anything successfully for a diverse people, there must be compromise. If you're getting 100% of what you want and the other side is getting none, you are evil and you are destroying your nation. You must control the emotional attachment to things with logic and reason. And the stronger you feel about something, the more you need to use your logic and reason so that you can come up with something that is agreeable to everybody and we can pass it. We get 50% of what we want, you get 50% of what you want. That's how this nation was built, and built the most powerful economy that the world, to my knowledge, has ever had. Look up also, again, Yuri Bezmenov, B-E-Z-M-E-N-O-V, a KGB agent who defected from the KGB. He talks about the whole process of converting a country to communism, and boy, does he talk about things going on in the United States if you just look. What else? I think that probably is enough for me to say.
Albert, I think you missed your calling. You should have been a professor of common sense and law at the Southern Methodist University, I think. Well, I wanted to amplify a little bit about my snarky comment about left-leaning faculty at SMU and heads full of mush. I think they're both true because, let me use an example of the University of Texas at Austin, which is a bigger place. Faculties and students don't come from the locale. They are not steeped and learned in the traditions and policies of people in the Southwest and Texas, which are different from those in the Northeast. One of my favorite examples is the Suffrage Act. People used to say that, well, women can't vote. Well, that's not exactly true. It's only true in the eastern part of the United States. In the western part, prior to that constitutional 19th Amendment coming in, women voted for everything, and they included voting in federal elections. So to have a university, which is supposedly a conveyor of education and learning to your students, when you have a faculty that comes from outside, they have a different set of values. And also, the learned part of our society is kind of been given up to the left wing, which I'm sure is very acceptable to some people here, but not to most of us. If you're going to make a basic decision in any university, whether it's about gun rights, my contention would be that the decision should not be solely the faculty and the students. You need a term called stakeholder. A stakeholder in the University of Texas or the Massachusetts Institute of Technology or Southern Methodist would be someone who is a student who graduated, a student who didn't graduate, someone who is, all the stakeholders really include people who are dead. They include, in Texas, the taxpayers that pay for most of the freight down there. And I think for a itinerant faculty, which does not have the knowledge of local customs and rules and laws, who are catering to the the approbation of their other colleagues in other parts of the country, are not entitled or capable of making a fundamental decision like this. So that's why you can have a left-leaning faculty in the middle of the Park Cities, because they're an island. 2 or 3 or 4 little things in quick passing here. Number one, if the people who are opposed to guns, and who worship at free speech, if they apply the same standards to gun laws, then the standard would be that you would be required to own a gun before you could vote. Civil war. Someone referred to the American Revolution as being a civil war. It was no longer a civil war than the one we had in this country, because a civil war is where 2 or more parties are competing for control of the country. Spain had a 3-sided civil war. We had a war of succession twice, once from England and the South that was successful, thank goodness, and the one from the South seceding from the North, which was not successful, thank goodness. Citizens United is widely decried among the left as being a horrible transfer of power to the wealthy. Well, nothing could be further from the truth. It is just like the court said, it's free speech. And here's a perfect example. We have a man who is probably the best known contender for the Republican nomination for president in Jeb Bush. He has spent over $100 million in his campaign, most of it on media. The second most highest expenditures is Rubio at $49 million. The lowest one is the guy from New York City, Donald Trump. He spent $10 million. Bushy can't get above 5%. And I think that should demolish any argument that money can buy an election. Let's see. No constitution. I have often struggled with why monarchy was so important to Europeans until I was reading stuff about Germany before World War II. And I think what you overlook, John, is that Europe may not have had constitutions, but they had a monarchy. And one of the purposes of a monarchy was maintain some kind of basic reference point for tradition and morals and the history of the country, but that's just a passing comment. And I guess one other thing that's maybe not relevant is George Washington was not our first president. There were 14 presidents before him. They were under the Articles of Confederation. We never study them. I was just reminded of that recently, and I think our first president's name was John Hanson. So now, unlike 90% of the other 300 million people, you know the truth.
Okay. As far as our speaker is concerned, I thought that he did a splendid job of making a legal argument. I couldn't argue with him even if I was as well-trained and had a background like him, because I think he's a brilliant man, and I think he did a terrific job. The problem, as always, is with interpretation. We all know that laws, okay, have been put together that have been used against people. They've been used to further the interests of elites, okay? And the fact that you can put together an airtight analysis that shows that you're constitutionally correct, all it means is that you put together an airtight analysis. It doesn't mean that it's right. Right? Which brings me to the point of where I depart from agreeing with our esteemed speaker. Very smart guy. I happen to disagree with him, but I think that the thing that people need to keep in mind is there is a difference between law and doing what's right. Okay? And I'm going to leave you to your conscience and your values to decide what's right. But I am going to warn people, okay, that the most sophisticated arguments may not be right. All right. The second thing is I take exception to the blanket assessments that have been made. Just because 2 major universities in this state, which are private, okay, have made decisions you don't like, it doesn't mean that all these people are paranoid. And it doesn't mean that they're left-leaning. What it means is they made a decision that you don't like. That's all I got to say.
I think that Jim has pulled the moral authority here out of the rabbit's hat. And I want to talk about that real briefly. What does the Second Amendment mean? It means that gays can be armed. They can protect themselves. It means that women can be armed. They can protect themselves. It means that shop owners or business owners who have to carry cash, they can be armed. All these situations where predators move in, what the Second Amendment does is it gives us the right to protect ourselves. I can't think of anything more morally sound than that.
Maybe one more quick. I was just reading where in Copenhagen, a teenage girl happened to pull out a pepper spray and save herself from being raped by one of these Mideast immigrants. Well, since they don't like weapons there, she's being prosecuted for possession and use of an illegal weapon. This is insanity.
I guess I'm the last man standing. Anyway, I want to thank our speaker for tonight. He did a terrific job. He got us all thinking, and it's thinking in the right way, what we need to do to go ahead. I'm looking, I ran against Henry Hyde in '94, and at that time he had passed the assault weapons ban in Congress, which assault weapons then were semi-automatics that look menacing. He called them assault weapons. I think the word assault weapons has been bandied about. Anyway, they threw that out years later. The NRA was against assault weapons because of that, because it wasn't defined. It never came down. Prior to that time, fully automatic machine guns were considered assault weapons, and they were banned. But semi-automatics were not. Our speaker tonight mentioned assault weapons, that they're all over the country, which they are. They're mostly semi-automatic weapons. And I think that that's not the problem. The real problem today is we have so many gun deaths in this country that people are getting alarmed. And there has to be a way to, and people with mental disabilities have gotten a hold of guns and killed people. They happened in Sandy Hook and other places, kids were killed. So what is the real problem? What can a society do to curb that without impeding the Second Amendment rights, which I don't ever want to see impeded, because a society has to be able to have the weapons to avoid a tyrannical government ever happening to them, which has happened in other places. Anyway, my point in passing is simply this: there should be an onus on the gun owner for securing his weapon. If a gun owner secures a weapon, if a mental patient gets a hold of that gun and kills somebody, there should be some responsibility for the owner of a weapon to secure that weapon. And if that were in place, a lot of these gun deaths would not, a lot of people with disabilities would never get the guns. So you put that together with stronger enforcement as far as check for, I forget what you call it now, I'm losing it. When you're buying a weapon, you have to background checks, stronger enforcement for background checks tied with some responsibility for owners to secure their weapons. I think that would do wonders to prevent gun deaths that are going on in this country, which everybody's alarmed about. So anyway, that's all I have to say. And one other thing, I'd like our speaker to show how he feels that the correct decision which he discussed relates to being able to curb firearms and violence. That was never discussed. Thank you. Oh, he wants me to also, I'll use his I'm the last one standing, so I'll say this. There's a, he wanted, what was it you wanted the address of where, the address was 5455 La Sierra Drive, Dallas, near Central Expressway and Walnut Hill Lane. 5455 La Sierra Drive, Dallas, Texas. That was what he talked about earlier. All right. Our speaker now gets to comment on a comment and close this meeting. He gets the last word. Come on up here.
I had to make a list of things that I wasn't going to comment. I had to cross the Civil War off the list of things I was going to comment on. With regard to the relationship between the two clauses, the Second Amendment wasn't written by English professors. As I said, the placement of the commas was changed 3 times during the course of the ratification. Plus, I mean, it says what it says. You know, it's the second clause makes perfect sense without the first clause. The right of the people to keep and bear arms shall not be infringed. Is that difficult? The right of the people to keep and bear arms shall not be infringed. Do we need a clause about the militia to explain what that means? Didn't we talk about what the word people means? Yes, I presented some sophisticated arguments, but we looked at the actual language. We saw the use of the word state. We saw the use of the word people. We saw the use of the word militia. We looked at the definitions that the Supreme Court has given as to who are the people. So, yeah, there were some sophisticated arguments, but there are some pretty simple arguments. And that's where I started, was with the simple arguments. You look at it, you read it, you see what it says. Now, the interpretation of legal documents is not, again, made by English professors and English language rules. It's made by rules of construction, rules of interpretation, canons of constructions. Those are quite solely different from whatever the English professor says it means. It means what the rules of construction that the legislatures and people agree to abide by. Plus, a lot of the rules of English that we have today were not firmly established back in 1792 or whenever you want to talk about it. Okay, we also briefly mentioned assault weapons versus assault rifles. There is, the way these terms have evolved now, the two are very, very similar. An assault weapon, however, has no capacity to fire in fully automatic. An assault rifle usually has a selector where you can select automatic or semi-automatic. Okay, so that's the difference between an assault weapon and an assault rifle. Assault rifles were invented by the Germans back in World War II. An assault weapon, that's what they're currently talking about banning, cannot be fired on full automatic. In fact, most people can't own fully automatic weapons. There's a lot of legal hoops you have to jump through to be able to legally own a fully automatic weapon. Okay, I really don't know much about TCU, so I wasn't really talking about them. I was talking about, in general, about academia. Okay, there's lots of evidence to support this. You look at surveys of faculty members that have been done across the nation for a number of years, and almost all, well, not almost all, the great majority of faculty members identify themselves as liberal or to the left of liberal. If you want to see what's going on at most universities today in terms of First Amendment rights, go to a website called FIRE, the Foundation for Individual Rights in Education, fire.org. And you will see the lawsuits that they have brought on behalf of students at public universities whose First Amendment rights were violated. And you will find that almost all of the people whose First Amendment rights were violated or were trampled on were basically what we might call conservative right-wing students. Okay, I think if you look at the big picture, you'll see that academia is in fact dominated in general by the left. And then the left is very disrespectful of First Amendment rights on campus, is very disrespectful of due process rights on campus. And I'm not saying that private religious universities are any better, but these places are not, these places are not havens for free speech. Now, with regard to our Constitution, it's not just a piece of paper, it's the supreme law of the land, okay? This is arguably what made us first in terms of freedom. You won't find as much freedom, for better or for worse, in America. We have more freedom than anybody else. Why? Because we have a Constitution, we have a Bill of Rights written. We have a lot more freedom than the British do. The British have to support a monarch. They don't have separation of church and state. Their First Amendment rights are not as strong as ours. Their police are not subject to the strong restrictions that our police are said to. So England's a nice place, but I don't think we want to model ourselves after them. A lot of people complain about federal power. Yeah, the problem is we don't have. The problem is not too much federal power. The problem is the way they're using it. Okay, say you transfer a lot of these federal powers to states. You think things would be any better? Did state and local governments handle the Flint thing well? No. The states and federal governments are led by people who are equally as incompetent as the people who are leading the federal government. All you're doing is exchanging one set of incompetent masters from another set of incompetent masters when you transfer powers from the feds to the states. What we have to do is get quality leadership. People with integrity, people who aren't bought and sold by special interests. Now, how do we get there? I don't know. The problem, though, is the two-party system. You have to be a good old boy to get the nomination of Democrat to Republican. You have to spend the right money and know the right people. The two-party system, both political parties are corrupt. Therefore, we have corrupt political institutions. Therefore, we have failing corrupt political institutions. The Dred Scott decision. I cited the Dred Scott decision not because it was correct, but because it showed what the Chief Justice of the United States Supreme Court in 1857 thought the Second Amendment said. Okay, he was a lot closer to the actual founding of the Second Amendment than people are today. What you want to do is, who are the people who are aware of the early history, like I'm sure Chief Justice Taney was, and he clearly said, I think he made it clear that it was an individual right. So he wasn't being quoted because he was right. He was being quoted because it was evidence of what the legal authorities thought at that time. Now, with regard to ambiguity, in the terms that whether using that for legal construction means has multiple possible meanings. Okay, does the term "the right of the people to keep and bear arms" have multiple meanings? Okay, not the Ninth Amendment. Is the Ninth Amendment ambiguous? Okay, the Ninth Amendment, all it says is it's dealing with one of these legal constructions, unio alteris something, that the failure to mention something does not imply that it doesn't exist. That's all that means. It isn't attempting to list what those rights are. The Supreme Court doesn't throw up its hands and say, "Oh, that's ambiguous, we can't figure it out." You go figure it out. And that's what they did. You know, the right of the people to keep and bear arms, that's not that difficult to figure out what that meant, especially in the context of the other provisions of the Bill of Rights. If you don't like the Second Amendment, you don't like Heller versus D.C., you don't like Citizens United, we have a way to deal with it. It's called amending the Constitution. Read your Constitution and you'll see that there are two ways to get on it, okay? A lot of people are very good about complaining, but when it comes to getting something done, it never seems to get done. You don't like it, get the Constitution Amendment. Start doing something constructive rather than shooting off your mouth and criticizing things. Do it. Amend the Constitution if you don't like it. The Supreme Court has never said that any provision in the Bill of Rights is ambiguous. Okay? They don't think it's ambiguous. And if you want it to be ambiguous, it's ambiguous. But the right of the people to keep and bear arms is not an ambiguous phrase. Okay, finally, as I thought I made clear at the end, the Second Amendment doesn't place a lot of limits on gun control. I would think that background checks would be constitutional. I don't see any problems with background checks. If you're allowed to keep mentally ill and felons from getting weapons, you have to have some procedure to find out who they are and keep them from getting it. Background checks make a lot of sense to me. I have no problem with that. I'm sure they would be found constitutional. I have a little bit more of a problem with the assault weapons ban because there are so many of them and they are in common use. Now, in an urban setting, an assault weapon makes absolutely no sense as a defensive weapon. But if you live out in the sticks, it makes a lot of sense as a defensive weapon. And that's a problem that us urban people have. We sort of don't get it, what it's like to live out in the sticks. I've lived out in the sticks, and I'm sure a lot of you have lived out in the sticks. You call the cops, how long is it going to take somebody to get there? 30 minutes? 40 minutes? Go out to West Texas sometime. Look around. You'll see that's a heck of a long time from some of these places for the cops to get there, if they can find it. Because a lot of places don't even have street signs. They don't have street numbers. I would suggest you go to Tooele, Texas sometime and look around, see what it's like. So what seems like a really good idea from the perspective of urban people might not really be a good idea from the perspective of rural and small town people. Don't forget these folks. Their numbers are diminishing, but they have rights. Anyway, I want to apologize if I was short with anyone. I was a prosecutor and a defense attorney at one time so I'm always going for the jugular, and I always have something smart to say. So I apologize. That's just old habits die hard. Okay, thank you.
Well, that's it for tonight here. This place closes at 10:30, just so you know, so we usually go out into the other room there and let the people clean this room up and carry on the conversation. Some people play music. It's all, just keep things going. Carry on the conversation and talk to our speaker, whatever. So thanks again. We'll see you next week.